Good evening, everyone. I am CA Mansi Mishra, moderator of today's webinar. We are delighted to welcome you all in the webinar being organized by CCLEA and NPO Committee of ICAI. It is my pleasure to be a moderator in webinar on Mediation Act 2023, an institutionalized way forward for growth and peace on 29th August 2024 from 5 p.m. to 7 p.m. being organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICI. In a short while, we will start this webinar. I would like to apprise you about CCLEA and NPO Committee. This committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation to develop and publish technical guidance, background materials, etc., and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Our eminent speaker will talk about Mediation Act 2023 and an institutionalized way forward for growth and peace in this webinar, and we hope that the same shall be useful to all the members. Now moving forward with the introduction of today's speaker, Sir C.A. Virendra Kumar Gupta. Sir is BCom LLB, and as you know, Sir is CA and advocate also, and having experience of practice of more than 18 years as a CA and 6 years as a legal consultant also. 5 years experience of administration, finance, and management in private sector at higher managerial positions. Further, judicial experience of more than 8 years as member ITAT and NCLT. Presently, Sir is practicing as an advocate in Mumbai after completion of tenure as member technical NCLT, mainly in corporate laws, insolvency laws, direct tax, mediation, and arbitration. Sir has been member technical in NCLT, Ministry of Corporate Affairs, Government of India, Kolkata, Ahmedabad, and Allahabad branch between 3rd of July 2019 up to 2nd July 2022. Sir has disposed of matters pertaining to Insolvency and Bankruptcy Code 2016 and Companies Act 2013, authored certain landmark judgments as well. Sir is president and Sir has been president and chief financial officer of CMAC Limited Mumbai. Overall responsibility, finance and accounts, technical taxation, purchase, crew management, and member of core committee of top management has been handled by Sir. He has been an accountant member of ITAT, Ministry of Law and Justice, Government of India, Mumbai, Nagpur, and Indore bench. He has heard and disposed of appeals pertaining to direct tax laws. Sir has been CEO of Jackson International Limited, New Delhi. He was responsible for all the functions and day-to-day affairs of the company, reporting directly to CMD. So many accomplishments by Sir. I feel so privileged to introduce you, Sir. Sir has been working experience. Sir has a working experience at senior position in corporate sector. He has a professional experience in the field of management, business advisory, finance, accounting, audit, and law. In addition to that, he has got judiciary experience as a member of economically significant institutions like ITAT and NCLT. He has approximately 3,500 cases disposed of as a member of ITAT during the period of 5.5 years, disposal of different benches as a whole, approximately 6,000 cases. 1,100 cases disposed of at Kolkata branch bench 2 within 8 months, and 1975 cases disposed of at Ahmedabad bench within a period of 1.5 years during COVID-19 pandemic. 685 cases disposed of at an Allahabad bench in 7.5 months, 186 cases disposed of in bench 4 New Delhi in 1 month. Orders passed within 7 to 10 working days from the date of hearing. Further, more than 99% of the orders confirmed by higher judicial forums. Many orders passed in IT/AT have been reported in leading tax magazines such as Income Tax Tribunal Decisions, Income Tax Reports, CTR, Taxman, etc. Similarly, the orders passed in NCLT have also been reported in various magazines and websites reporting orders under IBC 2016. As President and CFO of CEMAC Limited, savings of more than 100 crores for company in a span of 4.5 years through personal initiative by way of rationalization of purchase processes, crew management and capex on operations has been done by Sir. As CEO of Jackson's International, he also carried out salvage operations of RIG owned by the company and drilled deepest of ever offshore well in India in that time. As a practicing CA, pursued clients to avoid tax evasion and guided them not to enter into avoidable tax litigations. Hence, only 5 appeals during practicing career of 18 years. Sir is a learning individual having ownership attitude and believes in team spirit and ethical working. He can handle projects covering legal framework, management, commercial, operational, taxation, and entrepreneurial perspectives. We welcome you, sir, in today's webinar.
Thank you so much for giving such a detailed introduction, which was not meant to be, but that was given for concise.
No, amazing interview, sir, and definitely it has to be there.
So,
Sir, can I assist you with the sharing of your presentation?
Yes, that's the PPT which I have sent. That
Sure.
that would be helping the others to understand.
So please confirm, is it visible?
I am not able to see it. I am not able to see it.
Okay, wait.
Now it's visible.
Okay, sir.
Now it's
Just
visible.
okay. Just a minute. Okay, sir.
Yeah. Thank you. Thank you so much, Mansi.
Okay, sir.
She has given much detailed introduction, which was not, in fact, needed. And I must humbly say that uh, I don't possess any those qualities which have been. I am a. I have worked always as a doer, as not as a doer, but as a means, because I believe that Krishna is the source of energy in Srimad Bhagavad Gita ji. He has said that he gives you the wisdom, intellect, and takes away. And to whatever jobs and assignments you have to do in life, he will be with you for those jobs. So, and in fact, being a great example of grace and mercy of Lord Krishna. So, with this opening understanding of my life and achievements, I hope that I will stand up to your expectations of all the participants. So, this is the title when I was thinking what title should be. So it is something it is something struck to me based upon my judicial experience. in NCLT, because in NCLT, uh, mainly there were a lot of disputes between families relating to operation and mismanagement. And I found that those parties not only came to a standstill, became bankrupt practically from having a high level of growth, and their family peace and personal peace was also greatly disturbed. And they were at loggerheads, spending millions of rupees on litigation. So that insight gave me to, because what is happening, mediation is as old as the, you can skip all, Mansi, you can skip the, you can forward the slides. I will try to be extempore. Next slide, please. Yes. So the concept or practice of mediation is as old as differences and disputes between human interactions since ages. So, but not much uh, empirical evidence is available before us, except the things that the panchayats were there, mahajans were there, and other kulas or so many other institutions were always present in our society. Not only in our society, all around the globe in one or the other form. However, the, no is no institutions were formal and having a process of legal base. So with that, so post independence in some early part of 20th century, there were efforts to formalize that. But to understand the basic meaning in a layman's language, first of all, what I have learned during my judicial process, judicial assignments, and throughout my career as a chartered accountant, how to understand a law and how to understand the nitty-gritties of law of any issue. So a natural inclination came without understanding the background and history of the purpose of the law cannot be understood. And for that, we have to look in brief the and sometimes if there is the best source to understand a concise meaning is to go first to the dictionary meaning, what that term has been defined in dictionary, so a layman can understand. So in as regard to mediation, I found that mediation is a process is known as shuttle, this defined as shuttle diplomacy. So mediator has to be between two parties going uh, from this court to that court, and the parties are not inclined to hold direct interactions and discussions. So with this way, you can understand the role of a mediator. That is the role of a mediator and the position of a mediator. Another definition is to bring the disagreed parties to the table and try to find an amicable solution. So if solution is found, what happens then thereafter? The parties to the dispute can focus on growth, both economic and personal. They can have next slide, please. They can have they can have interpersonal relationship in a very cordial manner. In that sense, it is mediation is a mode of attainment of peace. Peace. This is the human aspect. Once you are away from the disputes and litigation, you have a lot of peace. And it gives peace not only to the parties to the dispute, but who are the other participants and actors, mediator, and the other entities involved. They also find great satisfaction. At least something could be achieved in a positive manner. So peace is there, growth is there. Even though growth may not be there, but certainly peace will be there. So that is the rationale and philosophy behind the title of that. How to understand, because some people say chartering way, new road ahead, quality reducing. Simultaneously, other objectives, that is to reduce the burden of the formal judiciary, is also achieved. It is cost effective. It is time. It is. It has. It takes short time as compared to other modes of. And if this culture is propagated, our society will become less litigative, which is a basic flaw in our approach at the moment. So these are the opening words for regarding title and understanding. Next slide, please. Now, the growth of alternative dispute resolution mechanism, which imbibes in itself mediation also. So the efforts were made and necessity was felt from early part of the 20th century. So first formal ADR mechanism was made by way of enactment of Arbitration Act 1940. And thereafter, I have mentioned this mechanism of mediation being recognized as a way of resolving the disputes, each legislation wise. First, that starts with Industrial Disputes Act 1947 and comes to at you will see thereafter uh, everything thereafter so many legislations have been made to, and even on in the CPC there were made amendments in 2015. Section Commercial Courts Act 2015 was incorporated specifically for pre-institution litigation. So can we move forward to the next slide? So what I mentioned, that was the judicial legislative efforts from the government side. But these efforts were also as a result of international developments, signing of various conventions or treaties, and a desire expressed by or observations made by the higher judiciary in so many judgments. So these and committees were formed. So there was a again. So first of all, Section 89 in the CPC was incorporated with effect from 1/7/2002. Thereafter, major amendment came in by way of Commercial Courts Act 2015, which introduced Section 12A, which mandated to go for a pre-institution litigation mediation. Uh, Initially, the government intent is very clear. Initially, the specified value for such disputes was 1 crore, but by way of amendment in in 2018, the that limit was reduced to 3 lakhs only. And it is in line of the government to do the ease of doing, to get ease of doing business and ease of living, specifically the word of ease of living. If you are litigation free, so you are always free from that unrest in your mind. There are certain decisions which I have mentioned for the benefit of the participants that that have upheld those efforts and also encouraged the formalization and establishment of the mediation institutions through in the court itself. So these are the decisions which which have been mentioned here. In the case of party automation, the Honorable Supreme Court upheld the mandatory nature of the Section 12A of the Commercial Codes Act 2015. Similarly, in other cases, why I am mentioning these cases? Because these are the cases of, in all these cases, there was necessity felt for mediation. And even you will see further that as early as 2002, some private mediation was. Can we move to next slide, please? Yes, private initiatives were taken in the field of ADR. And in Ahmedabad, as early as 2002, lawyers and advocates joined hands to establish an institute for the purpose of encouraging the litigants to go for the path of mediation and settle their disputes. Supreme Court, next, particularly in two cases, Supreme Court in the case of Mr. Vikram Bakshi, and there is a case, near case, Mr. Next, please, slide, please. M.R. Krishnamurti. M.R. Krishnamurti. There were specific observations to promote mediation and have formal infrastructure for that. In 2019, a significant development happened globally when India signed United Nations Convention on International Settlement Agreements resulting from mediation, popularly known as Singapore Convention on Mediation. However, though it has not been ratified so far. So all these developments globally and domestically led to preparation of mediation bill, and a formal bill was presented in the Rajya Sabha in 2021, which was referred to the Parliamentary Standing Committee, for their review and suggestions. And finally, this after their suggestions were received, it was again presented in the Parliament as Mediation Bill 2023, which came into effect on 15 September 2023. Government of India had also formed a committee to draft the rules and regulations simultaneously, and which also gave its report before the Mediation Act 2023 was promulgated and became notified on 31st August 2023. Next slide, please. So, by notification dated 2/9/2023, 21 sections of the Mediation Act have been made operational. And regarding other sections, and to make the Mediation Act fully operational, interministerial consultations are on various sections and rules and regulations. And it is hoped that Mediation Council will come into existence, into actual operational existence by the end of 2024. In the meanwhile, Government of India and state governments have also initiated process to frame guidelines and schemes to resolve their disputes where they are one of the parties through mediation process. In fact, Department of Expenditure, Ministry of Finance, Government of India in June 2024 issued a circular to various departments, the central government, to formalize the mechanism of mediation in their contracts and tenders. And also, one fact which can also give an insight into the intent of the government is that in that circular, ministry has asked to restrict the arbitration to a dispute up to 10 crores only in value. This contract may be of higher value, but the dispute should be restricted up to a maximum amount of 10 crores. And therefore, one can understand that how the government is intending to use the mediation process to resolve the disputes, because, where governments or its bodies or entities or controlled by it are a party to a dispute. And as we know that in most of the cases, Government of India is the government, including state governments, are the biggest litigants in disputes of this nature. So now with the Mediation Act coming into operation, hopefully that the process of resolution will change, mechanism will change, and we will see that reduced burden on the judiciary, formal judiciary, and the disputes getting resolved in a short time with in a cost-effective manner. So, can we move Mansi for the next slide, please? Uh, Now, now we come to the actual structure analysis of the Mediation Act 2023. So, uh, when I started practicing and also joined the judicial quasi-judicial bodies, I was I was guided by my seniors to how to approach to a dispute or dispute. So first of foremost, they guided me that for understanding any law, the purpose of a statute along with its legislative history needs to be looked into. History, that is the historical background has already been perused by understanding, which shows that the whole society, advocates, government, and judiciary were always feeling a necessity, and that has culminated into the promulgation of Mediation Act 2023, which consists of 65 sections divided under 11 chapters and 10 schedules. So that is the once we know that this is the ambit of Mediation Act, and rules and regulations are yet to be finalized and notified. So that though draft regulations, as stated earlier, have been submitted by the committee headed by uh, Mr. P.K. Malhotra, ex-law secretary. Okay, now we will have to come to this for understanding the purpose of act. That's very important. One needs to look at the preamble and preamble to the preamble, because the preamble is the source of law, and it reflects the intent of the legislature, what they want to achieve by enacting any law. So it contains 6 objects in the order which I have mentioned in the order of preference. First, first object is to promote and facilitate mediation, especially institutional mediation for resolution of disputes, commercial or otherwise. That is important. The, to promote and facilitate, these are the 2 words, mediation, and the intent is it should be through institutional mediation of what? Commercial disputes or other disputes. So that is one thing. Or another thing was that there was an ambiguity regarding enforcement of mediation agreements, mediation settlement agreements, because there was no law. So, where there were laws, there were provisions in those laws for enforcement. That could be one case instance, but how to enforce it? So it was a mediation settlement agreement was mostly enforced through treating it as a contract. Parties entered into a settlement and that was considered to be contract. But now this Mediation Act has approached and made enforcement of mediated settlement agreements mechanism, how it will be enforced. For third object is establishment of a body for registration of mediator. This is also very to be understood very clearly. Now, since the focus is on institutional mediation, so there should be a body of mediators. When in the next slide, when before we will see who are the actors and players in the Mediation Act, but for the registration of mediators, there is a establishment of body that is known as Mediation Council of India. Another important object, fourth number, is to encourage community mediation. that is also one of the prime objects. If the disputes are of particular area between particular residents or localities or families, and that can be resolved through community mediation. So a lot of issues can be solved, and public safety, public health, or larger peace can be maintained. Now, the latest development is another objective to make online mediation as acceptable and cost-effective process. What the government with the technological developments, as we all know, that it has become possible to settle or have interactions through media online. Through several platforms are available. So online mediation i- is is also one of the preferred mode, maybe the preferred mode later on, not as of now, but it is, and it would be not surprising to note that a lot of institutions already exist for online mediation. The residual clause is for matters connected therewith or incidental thereto. So whatever, for first five objects uh, are prime objects, specific objects, which this Mediation Act aspires to achieve. And if anything comes which cannot be classified and that is needed to be done, the residuary power has been given to the central government. ठीक है. So next, now I said, as I said, for better understanding, it is desired to know who will be the players and institutions involved in mediation as facilitators. Can we please move to the next slide? So, Mediation Act, players and institutions in action. Parties to disputes. There are participants, experts, advisors, valuers, mediator, mediation service provider. Its role is of facilitator. Mediation council, its role of regulator. Mediation institutes, its role of education, certification of mediators, and various other objects which can be, it is in the field of skill development. And central government, which is legislator, executor, and policy makers also. So these are the players, and the different roles have been defined. One, just for reference purposes only, now the government is not creating any, not enacting any statute where the powers of legislation, execution, and uh, judicial decisions are vested in one institutions, which is the case with SEBI. SEBI is the regulator, facilitator, administrator. Though high-level committees or outside members are there to board, in the board also government nominees are there, but the Supreme Court in 2002, dealing in a case, observed, and the government acceded to that request, that any act which is on the field of commercial or economic activities should have different players. So following that, you can see in some Insolvency and Bankruptcy Code 2016, where adjudicating authority is separate, RP and Commercial Committee of Creditors is separate, IBBI is the regulator. So in this, on the same paradigms and same structure, these are the different players have been, different actors have been given. Mediator is there, mediation service provider is there, four institutions, five institutions are there mainly, which will create the regulatory framework and execute the mediation process. Parties to the dispute are the players in a sense ki they are the parties who seeks the redressal of their grievances through the medium of mediation. Mediation. So, with this understanding, when we will see the law, actual law, so we can understand the all the 11 chapters have been devoted to these players and the functioning of the Mediation Act as a whole. So you can understand once you go through. So it would facilitate your understanding what is the purpose, why this chapter is there, what these sections intend to achieve. So with these observations, I require, please move to next slide, please, Mansi. If you will see, just I have, though I know that participants know, but for my benefit itself, when I started studying the law after preamble, I used to do this exercise. To first understand what is the uh, whole structure of the law, one time, two time, then one should reach to the contents of each section and each provision. So chapter 1 is preliminary. In every, you will find in every institute after preamble there will be chapter 1 short title, extent and commencement. So similarly, section 1 of the Mediation Act prescribes for the extent of its jurisdiction, that it extends to whole of India, and it also prescribes provisions may come into effect on different dates. On different dates. So that is why I told that in section on 9th October 2023, section 1 to 3, section 31 to 38, section 45 to 47, 50 to 54, and section 56, 57 have been made operational, which in fact are related to the establishment of mediation council and functioning of the central government to bring the necessary rules and regulations into place so that the other provisions of the act can be operationalized. So this is one thing. This provides, and it is known as Mediation Act, which we are dealing with. Now come to chapter 2. Chapter 2 is application of the act. This is very important. This is this defines the scope and reach of the statute. It has to apply, the first condition is it has to apply where mediation is conducted in India. That is first part, which also goes in line with the preamble. And government intended to make India as a center or hub for mediation globally and for domestic purposes to reduce the burden of the judiciary. There are 5 clauses which are mutually exclusive and cover the situations to which this act shall apply. That is where domestic mediation first is based upon the place of business oblique residence. If both the parties or both the parties are reside in or are incorporated or have their place of business in India, first condition. So it will apply to disputes relating to such parties. Second condition is that the mediation agreement between the parties provides that any dispute shall be resolved under in accordance with the provisions of this act. This is also very significant to understand that it is irrespective of parties and their place of residence. So wherever the parties may reside, may do the business, if they want to get their disputes resolved through a process of mediation in India, under this act, they can also go for this. Next, please, slide, please. Third is international mediation. So as the nomenclature explains itself, there this would involve some element of internationality. Section and before and incorporating the definition of intermediation here itself, section 3G definition clause it contains the definition of international mediation. So there is basically that definition is prescribing that any party, one party to the dispute would be having a place or business or residence outside India. So that is the there existing. Ab section 4.6 is also there, and section 3G also specifies, which I have mentioned there as another limitation, that the mediation must relate to a commercial dispute. As we have seen in the preamble, that dispute, commerce, commercial or otherwise. So there can be a situation of non-commercial disputes also. So that point we have to keep in mind, which we will be discussing later on. But in case of international mediation situation, which is to be conducted under this act, the criteria is that it should relate only to a commercial dispute. Other non-commercial dispute in the case of international mediation cannot be conducted and resolved under the Mediation Act 2023. The another situation is coming that which is also to be taken care of at present itself, that international mediation, there can be international mediation carried out outside India, though a party there too may be an Indian party, but same cannot be enforced in India under even even in that situation, because the Mediation Act applies to mediation conducted under this act. So whatever is not conducted under this act cannot be enforced under the provisions of Mediation Act 2023. So that limitation. For that purposes, what would happen in those cases? There are mechanisms, other type of arrangements which the parties will have to resort to, but that cannot be enforced under the provisions of this act. Fourth type of dispute is that specifically which has been covered, that is in relation to commercial disputes involving government bodies, public bodies, including entities controlled by the government. I am not deliberated, there may be deliberation. And the intent is that where the government is a stakeholder, directly or indirectly, the commercial disputes relating to such entities functioning can be sorted through the medium of mediation. Next, on the government, there was a parliamentary committee which focused on that why only commercial disputes. So, so there is a residuary provision which has been made that any other kind of dispute notified by the central government in respect of government or its representative bodies or control bodies can also be referred to mediation under this act for resolution thereof. So this is one. These are the five kinds of dispute, five kind of situations which Mediation Act shall apply. This is the application part. So taking section 2 and considering the preamble, so broad scope of the Mediation Act has been defined what it would cover. Now we will move to the definition section. Definitions definition clause is of great significance in any statute, because it gives meanings to the term extensively used in that statute later on, and so that the uniformity of interpretation remains. But there is one specific exception to this. Every definition clause as a norm would contain that unless the context otherwise requires. So similar is the case with opening language of the section 3. Unless the context otherwise requires, the different definitions given in section 3 shall have a uniform meaning for when the situation for arise for their interpretation, that the meaning shall be like this. Number one. Number two, can we move forward, please? Mansi, can we move forward? Another thing is, which is in every definition clause, and in the end, last, you will find there is a residual clause in definition section, which mentions that any term which has not been defined there can the meaning of the term can be taken from other statutes. So, however, in the case of this section 3 of the Mediation Act, no such residual clause is given, meaning thereby if a term is used which is not defined in section 3, so how to find a meaning of that term in case the interpretation of that term is involved. So now for that purpose, we will have to go to the dictionary meaning or general clauses act or other statutes having same purpose, or even we may be required to understand the meaning through customs and practices of that term, or as is generally understood in the business languages or business purposes, and business community understands that term. So understanding this, the structure of the definition clause is always like this. Now I will take you to the some important definitions of the section 3, which are of significance. So that is the most important definition is contained in clause 3a, small a, which simply defines that commercial dispute means a dispute defined in clause C of the section 1 of Commercial Codes Act 2015. There is no other definition. So that means by applying the doctrine of incorporation, definition given another statute has been incorporated under the Mediation Act 2023. So to find out the actual meaning, now we will have to go to the definition of the commercial dispute as given in section 21C of the Commercial Codes Act 2015, where 21 specific disputes arising out of transactions or agreements it is given, and specific situations have been given. If you will see, there are specific situations have been given there, which can be, and there is a general section about what does commercial dispute means. A dispute as per the section 21C of the Commercial Code Act. Commercial dispute means, it is a meaning, it's a definition which means it is exhaustive to a large extent. It will cover that dispute which are mentioned in the clause 21C itself only. So if you will see, first clause is ordinary transaction of merchants, bankers, financiers, and traders, such as those relating to the mercantile documents, including enforcement and interpretation of such documents, export or import of merchandise services, issues relating to admiralty and maritime law, carriage of goods, agreements relating to immovable property used exclusively in trade or commerce, franchise agreement. So there are 21 situations covered specifically arising out of these transactions, which are of the nature of commerce. So apart from that, there is one again residual clause, subclause in this clause 22 in section 21C. And such other commercial disputes as may be notified by the central government. So apart from these specific 21 situations, which is in consonance with the meaning word, So now, for expansion of scope of the term commercial dispute, the central government has been empowered to notify such dispute, which will be treated as of the nature of commercial disputes. And there is an explanation also given below this section 21C that commercial dispute shall not cease to be a commercial dispute merely because it involves action of recovery of a movable property or for realization of money out of removable property given as security or any other relief pertaining to immovable property. One of the contracting party is the state or any of its or agencies or instrumentally or a private body carrying out public functions. अगर ऐसी कोई स्टेट गवर्नमेंट की इंस्ट्रूमेंटलिटी भी है वो और जो कि कॉमर्शियल फंक्शंस कर रही है या इवन कर रही है तो दैट विल नॉट बी ए limiting factor to treat the dispute between such entities and other parties as of the nature of commercial dispute. So this is the definition of commercial dispute, which commercial dispute. But surprisingly, you will know that the word commercial, it comprises of two words: commercial oblique dispute, both. So neither the commercial word is defined in the Mediation Act, nor the dispute word is defined therein, independent of this dispute. So how to find the meaning of this term? So as said earlier, that we have to go to the dictionary meaning or General Clauses Act or other statutes or the definition of these two terms as judicially noticed in other legislations or other disputes. So this is the with this understanding we will have to interpret the whether because maximum times here I would like to give you a practical insight which I have seen in life. Ki, as whatever definition the Indian Contract Act 1872 says, a contract is an agreement enforceable at law. But in my view, what I have seen in life and you must have seen in life is that practically contract is an agreement which is binding only on weaker party. This is the practical and the party who is having undue advantage or wrongful gains will try every trick of the trade to continue with the advantage, that advantage. Therefore, why it is important to understand. So there are 21 clauses. So when I was noticing, so a question arose in my mind. This is considering this aspect, people will try to the party in advantageous position would try to say that it is not a commercial dispute. To my surprise, I found a few cases where there was a dispute relating to clause 21C7. Just for your benefit, I would read that clause again. That says, clause says, agreements relating to immovable property used extensively in trade or commerce. That these are the words. So all these extends what the word extensively, what the word used, and trade and commerce means, then only that if that all the four ingredients are satisfied and there is a dispute, then only it will be treated as of the nature of commercial dispute. So we have to be very clear and we have to understand there is a necessity, certain guidelines or notifications may be provided instead of so that the purpose of Mediation Act can be achieved. Otherwise, what would happen? That can be scuttled by the ulterior motive to dispute itself whether the dispute is of the commercial nature or not. For instance, Section 5, 6, subsection 6 of Insolvency and Bankruptcy Code, despite the term dispute. So a reference can be taken from that in case certain situations demand. So next slide, please. Whatever is written in the slide, I have already covered. Okay. Now, as stated earlier, there can be disputes which are not of the commercial nature, non-commercial dispute, would be in the nature of family disputes, partnership disputes, matrimonial disputes, disputes between neighbors, company matters, something tortuous liability. There can be things which are of the non-commercial dispute, but still, these can be referred to mediation. But here itself, I would like to make certain disputes which are not fit for mediation are mentioned in section 6 and second schedule, first schedule to the first schedule to the Mediation Act. That those definitions, those matters cannot be referred to mediation specifically. And the list given in first schedule is based upon the decision of the Honorable Supreme Court in the case of AFCONs that I already mentioned in the present in the previous slide. So, and this list can also be amended. First schedule can be amended. So it can be deleted, modified, or extended. So another thing is to be noted here itself that Section 56 of the Mediation Act provides that any that this act shall not apply to or in relation to any mediation commenced before coming into force of this act. So any pending proceeding is there, it shall not apply to those proceedings. Those proceedings shall continue to be governed by the respective legislations or modus operandi which has been prescribed other than this Mediation Act. So 3B में community mediator is there, which is relevant for the purpose of community mediation, which is in the chapter 10 perhaps there. So that is chapter 10, community court annexed mediation. This is also defined. It is relevant for the purpose of understanding the definition of mediation service providers, as well as what court annexed mediation means a mediation including pre-litigation mediation conducted at the centers established by any court or tribunal. Why it is important to understand, as I told earlier, that before coming of this act into play, the Supreme Court has and various high courts have in their established the mediation centers where the judiciary refers the disputes for mediation and mediation is conducted there and all the facilities and infrastructure is provided. So that is known as a court annexed mediation, which is different from court referred mediation in that sense. In the court referred mediation, generally court refers and parties to the disputes are to be the proceedings should be commenced or conducted in accordance with the model rules prescribed by the courts or otherwise by the courts and otherwise courts and other tribunals or institutions. Okay. Now the next definition which is important is institutional mediation. Means a mediation conducted under the aegis of mediation service provider. This we will deal when we will come to the relevant chapter. Mediation, that is important to understand this definition. Because general definition we have already seen that mediation is a process, includes a process. So this is an inclusive definition, whether referred to or by expression, mediation, pre-litigation mediation, online mediation, community mediation, the conciliation, or an expression of similar import, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third party referred to as a mediator who does not have the authority to impose a settlement upon the parties to the dispute. This is very important. This gives you whole gamut that it is voluntary in a sense, because and the mediator should be a third person who cannot impose a settlement upon the parties to the dispute, and different types of mediations, rather mediations have been referred to, including the meaning of the term mediation. And the most important to note is that it also includes conciliation. Hence, a conciliation. Hence, relevant provisions of the Arbitration and Conciliation Act 1906 are being amended accordingly. Section 61 and the sixth schedule to the Mediation Act provides uh, for such amendments accordingly. Once this Mediation Act 2023 comes into force, those provisions will become history of the history. So that is there. So this is the definition 3H, which gives you what is the it is a process, who conducts the process, what is its capacity, and what kinds of disputes can be what kinds of processes can be termed as mediation processes, various processes. And now the mediator means a person who is appointed to be a mediator by the parties or by a mediation service provider to undertake, and includes a person registered as mediator with the council. Council here means the mediation council of the India. When more than one mediator is appointed, the term will refer to all the mediators. Please move to next slide. Now this is very important also. Mediation agreement refer to section. This is the mediation agreement means refer to section 4(1) of the Act. We will deal with that. Mediation Institute, we will deal with that. Again, mediation service provider, we will come to the relevant agreement. Mediation settlement agreement referred to in section 19. We will deal with that. Online mediation, we will again deal with that. These are the participants. Participants, this is totally means persons other than the parties who participate in the mediation, and includes advisors, advocates, consultants, and any technical experts and observers. So this is why this is participants is wider term than the party. So there and there will be why the this term is important, because there is a confidentiality clause or privileges clause. So these persons have to be protected, and who participate, their what could be their role, which is defined in the later parts of the uh, act. Party is so simply party to party means to an agreement, mediation agreement and mediation proceedings whose agree to necessarily to resolve dispute and includes their successors. Successors have been included once the mediation proceedings as per the agreement which exists between the parties starts, or it will it will be binding on their successors also. Place of business that is being mentioned just for the purpose of reference, how in what three conditions are being given to include a consider what could be considered as a place of business. Can we move to the next, please? Next slide, please. 3U, pre-litigation mediation. Here it is defined, means a process of undertaking mediation as provided in the settlement of disputes prior to filing or of a suit or proceeding of civil or commercial nature in respect in in respect to a dispute before a court or notified tribunal under subsection 5(2). That is the pre-litigation mediation. So we will come to section 5. We will see. Now another thing is important thing is that there is a delegated or subordinated legislation clause. Now I will have to hurry because time is running now. I think so. the delegated legislation is something which gives power to the central government to frame the rules and to the Medical Council of India to frame the regulations. And these powers are contained in Section 51 and 52 of the Act. And the regulations framed by Medical Council of India, Mediation Council of India, have to be subordinate to the Act rules and rules made by the central government to carry out the purposes of the Act. So this is the defining is this defines the scope of the delegated legislation. Now can we move please forward please? Now this is 4.1. Now we have reached to the mediation process. Section 4.1 explains the contours of mediation agreement. One of the conditions is that it should be in writing. As we know that contract may or may not be in writing, oral contract is valid, but for mediation agreement, there is a condition, it should be in writing. And second condition is to what for what purpose is to submit to the mediation all or certain disputes which have arisen or may arise in future between the parties. So this is one condition. Section 4.2 provides that a mediation agreement can be in the form of a clause or a separate agreement. Section 4 provides that when the mediation clause will constitute a mediation agreement, it is that when such mediation clause forms a part of the mediation main agreement. So mediation clause will constitute as a mediation agreement. So we may have separate agreement for mediation, or in the main agreement, commercial agreement also we can have a clause for mediation. 4.3. What would constitute in writing? So there are various modes now having regard to that technology and other things. There have been prescribed that it will constitute as what would constitute as a mediation agreement in writing. What I have just can we skip this? I will not deliberate on that too much. There are sequencing of the sections and merging of the sections could have been done to not to for a better drafting. So I will not devote time on that. Now this is the important 5.1 prescribes whether any mediation agreement exists or not. The parties before starting proceedings of civil or commercial nature in any court with the mutual consent can with the mutual consent can refer the enter into can resolve the dispute by pre-litigation mediation. And now section 5.1. This is the so that means even if mediation agreement doesn't exist, still there is another option before initiating the legal suit that the parties can refer to the dispute to the mediation. There is no bar that in the absence of mediation agreement, nobody can go to the mediation, but they can go to the mediation with the mutual consent of all of both the parties in writing. Next slide, please. 5.2 is important. 5.1, sorry, proviso. There is a proviso to section 5.1, which is important to understand. That proviso, first I will read that proviso. That proviso says, provided that pre-litigation mediation in the matters of commercial disputes of a specified value shall be undertaken in accordance with the provisions of Section 12A of Commercial Courts Act and the rules made thereunder. So this is a very this proviso is of great significance. As noticed earlier, the specified value for a dispute of commercial dispute is 3 lakhs, and such dispute if the dispute commercial dispute is of this value or more, the mediation will be conducted in accordance with the provisions of Section 12A, rules made thereunder in the Commercial Act. So now there is Commercial Courts Act. So by this provision, that means ki commercial disputes of less than 3 lakhs or non-commercial dispute only can be referred to mediation to be conducted under the provisions of this act. If the dispute is of more than that specified value, commercial dispute, so that will be conducted in accordance with the provisions of Section 12A and rules made thereunder. And corresponding amendments have been done in Schedule Section 64 and Schedule 7th or something of the Mediation Act. Next, Section 5.2 expands the provisions of Section 5.1 to tribunals also. This can be done. Next slide, please. 5.3. Who can be a mediator? To conduct the subject to the agreement between the parties. A person who is registered with the these are the I am not devoting on time. These are the authorities which can be there, and a person is registered. He can be a mediator, can become a mediator. Subsection mediator for conducting the pre-litigation mediator. And there are other acts. Mechanism 678 also provides in case of uh, uh, motor accident claims, specifically through the medium of mediation. Now, this is important section which I have already referred to. Section 6 provide for dispute and matters not fit for mediation. First schedule to the act contains indicative list which can be amended, which is not exhaustive, which already dealt. I have already dealt. Can we proceed further, please? Yeah, there is another thing is Section 6.1 carve out an exception regarding settlement of compoundable offenses, compoundable matrimonial offenses through mediation. This is there, can be done. However, any outcome shall not be treated as a judgment or decree of a court, who shall further consider the same in accordance with the provisions of law having force in existing in force. So, what purpose it serves? Ultimately, the court, even if there is a settlement, it has to, how the burden will be reduced, I am unable to understand. But this is the provision says even compoundable offenses can be settled through mediation, in which some mediation part will be there, some court part will be there. And Section 7, power of court or tribunal to refer parties to mediation. Section 7.1 provides that if suppose a pre-litigation mediation has started under Section 5.1, but there is an event of non-settlement of dispute, even in that situation, court can or tribunal can refer to the parties to the mediation again. It may also pass suitable interim orders if deemed appropriate. Section it is important, however, in this situation, parties will not be bound to come to a settlement, even though court refers, but parties will not be bound to come to a settlement. And my observation is that can we read that just slightly up slide? How the court इंटरिम इसमें कोई कोर्ट के लिए इंटरिम ऑर्डर्स के लिए कोई गाइडलाइंस प्रेस्क्राइब नहीं किए. देयर आर हाउ ऑन व्हाट बेसिस and interim order is not appealable also, so that is open for abuse. That is, the party can abuse the process of law, who is in advantageous position to get an interim order, and settlement will not be bound, it will not be binding, or they can no settlement. In fact, no settlement can be made. That is the position. No necessity to mandatorily enter into a settlement. So this section needs to be considered in that light. What purpose it would be served. Section 8. Next. So anybody, including a person of foreign nationality, can be appointed as a mediator. However, uh, such person will have to possess such qualifications and experience and accreditation as may be specified. I would try to say wherever the words specified have been used, it referred to medical regulations made by the Medical Council of India, Mediation Council of India, and this uh, prescribed means rules made by the central government throughout the act. It will have these two terms will have the same meaning. So there are 8(2) may how the party shall be free to agree upon the name of the mediator and procedure for their appointment is provided the party can appoint. If party do not reach, they can refer. They can parties who is seeking the mediation may approach mediation service provider for the appointment of the mediator, and who will then he will appoint. And the mediator in that case will be appointed by the mediation service provider with pre-consent. However, in case the parties appoint such mediator, parties don't, in fact, the party do not appoint, they agree. There is a, again, I am not going to deal in detail. There are drafting mistakes which create some confusion in section 8(4). So, but in nutshell, from a present perspective, we can understand that parties, when reach to agreement, they can appoint, they can agree, and the mediation service provider can appoint. And if they don't agree, mediation service provider, with prior consent of such a person to be appointed, may appoint to act as mediator. In case these are the section 9, and while doing so, mediation service provider. Next slide, please. Will have to consider the preferences and other choices of the parties. And there are certain observations which I have made in my slide that there are, as I said, confusions and some corrections are may be required in some situations. Section 10, conflict of interest and disclosure. As we know, the person so appointed will have to disclose it. Otherwise, he cannot be, because his impartiality and independence cannot be compromised. So that is the case. So for that purpose, this is the provision. Before you give consent to act, you have to necessarily give this disclosure. Up suppose there is no disclosure in the beginning, but subsequently it happens, then immediately you have to disclose that. Again, as per the provisions of subsection 2. In that situation, parties may agree or may not agree. If the parties agree, in spite of disclosure, the mediator can continue. But if either party desire to replace the mediator, then such a mediator, on arising of a conflict of interest situation, will have to be replaced by the replaced in a sense by they can terminate either mediation service provider or the parties can terminate the mandate of the such mediator. These are the situations covered section 11 also. Next slide, please. Mediation service provider, and reappointment will be done under this is the clause provisions which I have given, how it will be done. Or if this also gives a termination of mandate of mediator, that there is one conflict of interest, or if the mediation service provider receives any information to that effect, though not disclosed, then termination can be done. But before terminating, following the principles of natural justice, such person shall be given an opportunity of hearing. Or option is also given to option is also exists with the mediator to withdraw from the mediation. Section 12 prescribes for how the replacement of mediator will be done in these situations. Next. Now, chapter 5, The chapter 5 is the procedural section containing section 13 to 26, which gives an how the mediation proceedings shall be conducted. It includes territorial, generally, जो territorial jurisdiction है court का to resolve the dispute from through court or criminal process, that will be the jurisdiction treated for the purpose of mediation. However, parties may agree for a different location or online data resolution platform, the dispute resolution platform for resolution, for for conducting mediation. But any mediation settlement, mediated settlement arrived within that will be constituted to have been arrived within the jurisdiction of that court. Next slide, please. When section 14 provides when the commencement of the mediation proceedings will happen. So these are the clauses. So and it is either with the party notifies or appointment of, it depends upon the mediator appointment and consent thereof. So it is simply a procedural clause. Now section 15 is important little bit. How? Section 15(1) says mediation process to be conducted in accordance with the provisions as specified uh, in the act, in accordance with the manner as specified to ensure consistency and a structured approach in mediation practices. These are the sections. 15(2)(3)(4) gives the guide the mediator to how to act and behave. And these are basically based to be objective, to be neutral, impartial, fair, and design the process also accordingly to reach to the solution in a shortest possible time within a time. And the mediator shall not be bound by uh, provisions of Civil Procedure Code 1908. So these are conduct of the mediation process can be moved, please, is an important part, and it has got guiding principles which will have to be adhered to by the mediator while conducting the mediation. Next slide, please. So this is what I have mentioned, that impartiality, objectivity, ये सब सारे provisions are like this: fair opportunity, effectiveness, timely conduct, orderly. So if you will and respecting the rights of the parties for self-determination. So these are the principles are extension of principles of natural justice and ethical practices. And a code of conduct can also be would also be specified by the mediation council. So these are the, and for this I would say only thing, we can remember the story of Panch Parameshwar written by Munshi Premchand, where two friends had different situations, and one situation, one friend decided that they became foe, and when the other that person conducted some, the matter was referred to the person against whom a decision was given by the friend, but the friend who had received the decision against him earlier decided according to the what the according to the nature of dispute and who was at fault. So the person has to be free from bias, whether personal or subject bias. So that is the quality of a mediator which is expected and incorporated in the provisions of law. And what is the role of mediator? That is very clear. It is just a facilitator, and it has to make very clear that the the mediation proceedings may result into settlement or not. The parties are supreme. Now next, there are restrictions on the mediator. If you have acted as a mediator in a proceeding, so there are restrictions. You cannot be appear in the proceedings if the mediation has failed as advocate, consultant, or as witness. So that is the provisions that it is there. Now comes questions how it section 18, can we move forward please? Section 18, time frame for it is 120 days, can be extended by another 60 days. That's all. This is the time it has to be completed. Mediated settlement agreement. What that is something with important to understand. Ki once all it may all or other some disputes may be settled. It should be signed by all the parties. It should be in writing and authenticated by the mediator. And how the mediated settlement agreement is will be provided. The mediator shall provide in case of institutional mediation to the MSP, mediation service provider, and in other cases to the parties to the dispute. Next, section 20. Registration is optional. It is not fixed. It can, well, it is not mandatory, but it is better to have registration. And there is a time limit for that, 180 days, which can be further be extended by payment of late fee. Section 21. Next slide, please. Section 21 is also important. This is a non-settlement report subject to the provisions of section 20, where no agreement is arrived, either provided in section 18, so or where the mediator is of the view. This is important that no settlement is possible. He shall submit the non-settlement report in case of institutional mediation to the MSP, mediation service provider, and in other cases to the parties. However, it is important to know that in such a report, it is very important that no proceedings, no fault, no other kinds of attribution, why it was could not be achieved, will be disclosed. That's very important. So that the party's position is not compromised in a suit or proceeding in case of non-settlement. That's the guidelines. Confidentiality is provided in section 22 and section 22. Next slide, please. It has to be confidentiality is a procedural clause and subject to certain exceptions. It has to be kept as confidential, which are prescribed in the act itself. Otherwise, confidentiality provisions are further as far as the exception is mediator settlement agreement for registration and enforcement or challenge. The confidentiality provision will not apply. Section 23, mediators, including we cannot be forced or permitted to disclose. Yeah, this is the privileges which has been described. They cannot be forced or compelled or can voluntarily disclose what was communicated, what happens during the course of mediation proceedings, who agreed, who did not agree, who was right, who was wrong, who was not willing, who are willing. So these are the factors which have to be uh, kept confidential. However, privilege or confidentiality can be breached. There are three situations which are mentioned in section 23(2). When there is a threat or a statement of plan to commit an offense punishable under any law, or where information comes into the position relating to domestic violence or child abuse, or where there is a danger to public safety or health. So these are the three circumstances when the actions of the parties can be disclosed to the concerned authorities. However, it is desired that some guidelines must be prescribed for these two sections, section 22 and 23. Now, section 24 is the clause of termination. It contains four conditions which are very clear. Either time limit as provided under section 18 is achieved and no settlement arrived on the expiry of the time. उससे पहले क्या है on the date of signing and authentication of mediator settlement agreement, or if the written declaration of the mediator after consultation with the parties or otherwise that further efforts and mediation are no longer justified. Why to linger when suppose normally the parties to the mediation come with their consent? However, There may be subsequent development there too. So in that situation, the mediator may say, after having consultation with the parties, it is not justified to linger on with the mediation proceedings and it can be terminated. On the date of commencement, communication by a party that party is withdrawing or opt out of the mediation. So that is also there. Section 25 prescribes for cost of mediation as may be specified that and which shall be shared and burdened by shared equally by the parties subject to agreement if there is which state that otherwise normally equally the parties have to share. Next, this is the this is the main section 626 is not that important. The provisions of will not be applicable of this act to Legal Services Authorities Act 1987. Now, it comes now section 27 and 28. We will have to discuss. 27 provides the that enforcement of a mediated settlement agreement uh, uh, shall be binding and final on the parties, and it can be enforced as an order or judgment of a court or tribunal in accordance with the procedures of section CPC 908 1908. And section 28 next section 10, that means if you have if you have agreed and signed mediated settlement agreement, that can be enforced as a, uh, a decree or judgment of a court or tribunal. So that was what was missing, that has been given an uniform for the purpose of unity, giving some judicial recognition to this, so that parties cannot later withdraw or deviate further. This can be uh, such a mediated settlement agreement can be used as an evidence in other proceedings. There is no bar thereafter. Section 28 is there are limited grounds to challenge the mediated settlement agreement. If suppose can be challenged, which can be challenged within 180 days, within 90 days, and a further period of 90 days if sufficient cause is being shown to the court. But the grounds are very important. It is only four grounds. Either mediated settlement agreement has been obtained on account of, has been arrived on account of fraud, corruption, impersonation, or it pertains to a matter not fit for mediation under section 6, read with schedule first schedule to the act. So only on limited these it can be challenged, and time limits have been prescribed. Limitation clause is there. Whatever time is consumed in mediation proceedings shall be excluded in the computing the period of limitation for filing suits or other proceedings. Now, next chapter is online mediation. It is very simple. Only one provision, section 30. It is given. Manner is to be specified. Online mediation includes conducted at any through online mediation processes, and confidentiality has to be maintained, and it is to be ensured that integrity of the proceedings has to be ensured. Now, chapter 7 uh, chapter 8 pertains to Medical Council of India, which we can, Mediation Council of India, which we can skip, except that is the section. This there are certain situations which may come into effect and can cause some issues, but not connected. It is what would be the composition, who can be a member, vacancies not to invalidate the proceedings, resignation, etc. And section 36 defines the section 38 is important to decide the functions which can be done for the purposes which I have already dealt while discussing the definition clause. So there is one provision, but not for our purposes. How the mediation concept now for that we will have to go to chapter 8, 9 first. chapter, can we skip to chapter 9, please? Mediation service provider, there are four categories of the bodies or institutions which can be and which can act as a mediation service provider. That is important. And mediation institutes. Mediation service provider is a body recognized by the council. That means mediation council. An authority under the Legal Services Authorities Act, court execs mediation center, or any other body as may be notified by the central government, uh, uh, the shall be deemed to be a mediation service provider recognized by the council. That means कि BCD clause में जो institutions हैं, that will be deemed to be recognized by the mediation council, and therefore what I have mentioned in the earlier provisions, that whether once these are the institutions which are deemed to be recognized, whether such recognition can be cancelled by the mediation council, because these institutions are either legislative creator or by the government or by the judicial authority which are hired to the mediation council of India. So then government will have to consider this while specifying the rules. Now next is my mediation institutes. Next clause. Mediation institutes are, definition is given. They will be providing body or organization that provides training, continuous, just like institute, continuing education and certification of mediators. Or it may also carry out such other functions as may be specified. There is nothing, unless the rules are specified, there is no other specification or guidelines have been given. So mediation institutes will be primarily engaged for three purposes which have been outlined in the definition clause. Now community mediation. Next slide, please. This is a very new concept which has been community mediation. I think we don't have time, and that is why, but simply any dispute likely to affect peace, harmony, and tranquility amongst the residents of area or any locality may be settled through community mediation with prior mutual consent of the parties to the dispute. It is not restricted to commercial dispute. It is generally community mediation. Some आपस में कोई जैसे आज the environment going, social environment going, but Section 44 provides for the provide the procedure for community who can be the mediator, respectable person, technical experts, which a panel may be maintained by the local government, district magistrate or judiciary. So these are the category of the people who will be involving to this man. But the condition is there, it shall not be enforceable as judgment or decree of a civil court. That is a limitation. Again, but all other provisions of mediated settlement agreement shall apply to this. Now there are the miscellaneous provisions contained to section 45 to 40 mediation fund, accounts and audit, power of central government, which I have already discussed that to function. Power of central government to issue directions. Section 47 is there, which can give directions to the Mediation Council of India as to function. However, the consultation may be done with the Mediation Council. Section 48 is also important. It enables central government or state governments or their entities or agencies to frame schemes and guidelines to which may be followed by them, or the process of mediation or conciliation may be conducted in accordance with such schemes. But this section is also creating some confusion. It is subject to the other provisions of the Act. Simultaneously, it says it may be conducted in accordance with the such schemes or guidelines. So what would happen to the rules or regulations made under Mediation Act? So if there is a conflict, the bodies or the authorities who follow what? That for that some clarification is required to be made. Now section 49. It simply said that where is a government is a party to a dispute, settlement agreement will not be arrived at without prior written conditions. Next slide. Next slide will not be arrived at prior approval of the competent authority, concerned competent authorities. So again, that means there is a safeguard mechanism. It should not happen that government becomes binding without, but no, it should be there should be a provision of some deemed approval. Suppose it should not vitiate the process of timeliness, the focus on timeliness. Section A 50 gives protection to various institutions and their constituents, primarily mediation council or mediation service providers or government authorities who act and participate and facilitate this process. Protection, if they act in good faith, they cannot be questioned before any court of law or other things. And this is section 53 and 54 are rituals. Whatever notifications, rules and regulations that have to be presented before the both houses of the parliament as per the normal practice. Or section 54 gives power to the central government to remove difficulties for the first 5 years of the commencement of act. Section 55 is that key provisions will have the effect, overriding effect on the any provisions of law except specific laws which have been mentioned in Schedule 6 to the Act. Section 56 we have already discussed, not to apply. 57, this is something, it is an interim arrangement. The rules in force governing the conduct on court annex mediation will continue, which have been framed by the Honorable Supreme Court in the FCONS and Salem Advocate Bar Association in 2005 judgment, and they will be continuing in force till the rules and regulations are specified. And for pending disputes, such rule may still continue after the framing of the regulations. Section 58 to 65 prescribes the various acts which will require amendment to align with the provisions of the Mediation Act 2023, and the relevant schedules thereto are third schedule to 10th schedule. This is in brief. Because of time limitation, I could have, that is why I have given a detailed presentation. It can be shared with the participants if the institute feels correct, so that on all the other provisions which I had to skip can be understood and glanced by the participants.
Sure, sir. Sure. Thank you so much, sir. Sir, if you have a minute or so, can we take up a question also?
Uh, 5 minutes only, because
Just
as
a
I told,
question, just a
yes,
single question, sir.
yeah.
If any person has any civil or commercial cases, can one of the party make application under this Mediation Act? And will the other party also be obligated to adhere to this act, or he has a right to deny?
As far as if it is of the other party, it is voluntary. Both the parties have to be. It
Both the
cannot happen.
parties have to
Both the
apply for
party
it.
have to give the consent. There is no,
Okay.
it's unless they give either agreement exists or Section 5(1) say doesn't agree, doesn't, if the agreement doesn't exist, then both the parties voluntarily and in writing they have to give their consent.
Yes, sir. You shared a slide where all the players were mentioned. So,
Yes.
all the players will be there in each and every mediation
No,
case.
no, no, no. If the suppose mediation service provider is there, mediation
Okay.
service provider includes court annex mediation center, online platform, but whatever platform one chooses, that we, if suppose Companies Act may, if the National Company Law Tribunal refers to mediation, then there will be a different procedure as per Companies Act, and under this act, Section 442 is also amended accordingly.
Okay.
Legal
Some
Services
of
Act
the
में,
parties will be
yes,
there
some,
in each and every case, but some
but
will
but
differ.
but the players are different kinds. Central government, mediation institutes, and Mediation Council of India, they have got different roles altogether. They will not be part of the mediation proceedings process. Only
Okay.
mediator and mediation service
Parties,
provider, parties to the dispute, and participants will
participants
always be there.
will always be there.
Yeah,
Right.
only that is it.
Okay, okay. Thank you so much, sir. So here we can end your session, and we understand that your time is highly precious, and still you carved out so much time with us. Thank you so much for. I will not say that it was just an overview of the act; it was a deep dive into the act. So thank you so much for an very informative session. We look forward for you to come in future as well.
On any subject, even on mediation, it is mediation, but I can also come on meditation and motivation.
Thank you,
Because
thank you.
what I feel that I've been given the best of the privileges with all humility by Krishna. So it is a payback time to the society. One thing to end, in the end, I would like to give a comment which I missed out, that mediation process has to be conducted with with substantial source of spirituality.
Hmm.
Unless if you see that commercial, if you see one parties or the mediator see only as a process of resolution of commercial or legal disputes with
Uh,
ego, the mediation will never
there
be
won't be
successful.
a
So
mediation.
mediator, there should be some prescription, some guiding spiritual force to all the participants rather, that only in that situation it will result into effectiveness.
So meditation should also be a part of mediation.
I thought some people must have not misunderstood my title, meditation for growth or peace or mediation. That is why I explained the purpose was that peace and growth both. First of all, peace is most important.
Right.
So if you are not at peace with you or with the others, you always lose the life.
In fact, the amount which has been given is very less. Like 3 lakh minimum amount is required to go for mediation is a very
Like 3
welcoming.
lakh
I
is
would say.
3 lakh is for section 12A.
12 only.
Any
Okay.
dispute over 3 lakh that will be conducted in accordance with the provisions of section 12A and rules made thereunder. Even a dispute less than 3 lakhs
Okay. They can also.
and non-commercial dispute can be resolved through mediation.
Okay. So it is a welcoming act for the nation, I would say.
Yes, certainly. Certainly, arbitration is restricted to 10 crores. So that shows the government intent is very clear. If the government do not want to exhaust arbitration, which has become a luxury.
Right. Okay, thank you so much, sir. And on behalf of my committee, I would like to thank you with all the gratitude. Thank you, sir.
On the contrary, I should say with humble hands, folded hands, it was a great opportunity to go into the law and to share my views. Hope I stand to meet the expectations of the participants.
Definitely, sir. Definitely, we are lucky to have you, sir. Thank you,
Thank you
sir.
so much.
Okay, sir.
God bless all.
Yes. Thank you.